On the slopes of Diamond Head. This is Kapiolani Community College. Kulia ika nu'u. Strive for the highest.
Aloha. Welcome to Business Law 200. This is the legal environment of business, and I'm Ben Carroll. Last time we looked at ethics, morality, the law, how they all fit together, how we determined what ethical behavior was, some decision making. And again, we'll get back to ethical requirements when we talk specifically about corporations. So now we pretty well wrapped up our general environment, our general background to the law. So today we're going to get into some substantive law. We're going to start looking at what the law says about specific things, torts, contracts, property, etc. So we're going to kind of get into the real meat of the subject. I hope you now have a good feeling for how the court system works, how laws are made, all of that kind of background material. Okay, so as usual, we're going to start out, we're going to do a quick review of what we covered before. So if you take a look at the review, how would you define ethics, and can something be legal and yet unethical or immoral? Okay, so I didn't make a distinction in my mind between morality, ethics, and law, and different people might cut that different ways, but the law is pretty clear. We know what the law is, and whether you consider something to be moral or ethical on the other side. Those kind of blend a little bit more with each other. But generally, ethics is considered to be behavior. In other words, our moral standards or our values applied to behavior. So we're looking at ethical behavior. In this, we have codes, we have standards of conduct, that sort of thing, that lets us know what ethical behavior is in certain circumstances. So we may be part of a profession that has ethical standards, or we may just in general say in business we think these are the appropriate standards. Can something be unethical or immoral and yet still be illegal? Well, certainly, since morality and ethics are more internal, you can personally feel that something should or should not be done, and the law may be determined something different. So the areas we looked at that are fairly common disputes in this area would be the end-of-life decisions and the pro-life decisions, that sort of thing. So you may feel abortion should never occur. The law says something different. You may think that at the end of life you should have the power to decide and get assistance in ending your life. The law may say something different. So we can certainly have differences between what is considered ethical and certainly what is considered moral by certain parts of the population, and what the law has determined is in fact the law. So again, the law often will incorporate ethical and moral decisions, and then they become the law and they have the government sanctions. But otherwise, the enforcement of other types of moral and ethical considerations that are not part of the law will be done by those specific groups. Okay. How is compliance with the law enforced, compliance with ethical codes, and compliance with moral precepts? So again, this is the major distinction we made with the law, because the law has government sanctions. The government will enforce the law. So, for example, on the crime side, we would have possibility of incarceration, fines paid to the state, restitution, monies paid to the victim, and in certain instances, in certain states and in the federal arena, we might have the possibility of the death penalty. On the civil side, we would have mostly monetary damages with the power of the court to require us to do something or not do something, like a temporary restraining order or injunctive relief. Now, an ethical code would be whatever organization or whatever group promotes that code. For example, Better Business Bureau is voluntary. If you don't comply with that and you're a member, they can either throw you out as a member, or they can indicate that until you come up to standards, you can't use their promotional material, that sort of thing. And morality, again, often associated with religious or another group, and that group will take whatever actions. They may banish you or shun you or not allow you to be part of the group, or if it's religious, excommunicate you. Take various steps indicating that you're not complying with those particular rules. Okay. Why would a business care about public opinion of your ethical practices? So perhaps you have an internal sense of what good business looks like. Perhaps for you, making profit is the number one thing. If you don't have your own internal ethical code, why would you care what other people think about your ethics? Well, from a purely practical standpoint, if you have a bad reputation, if people think you're dishonest, if they think you cut corners, if they think you don't meet what they consider to be the appropriate way of doing business, then they may take their business elsewhere. So they'll vote with their feet, and you will consequently have the possibility of losing business, losing profits. So even if you don't have some higher reason for complying with what the majority feels are appropriate business practices, you may want to do that simply to protect your profits. So we will talk more again in corporate responsibility about whether it's internally driven or externally, that sort of thing. Okay. If a business operates in different locales, how does it determine what's proper conduct? Well, if by proper conduct we're saying what's legal or illegal, then clearly we are subject, certainly the place we are operating will have laws, and that also our own laws from our own country where we're incorporated or where we're based may have laws as well. So we may be subject to several sets of requirements. And when we talked about American companies operating overseas, which again we will discuss further, there's the sense that, well, as an American company, I may have more constraints on me because of American law than other countries from Europe, Asia, etc. have on them when they're operating there. So it may be, in a sense, anti-competitive, and so I'm restrained, I'm not able to compete as well. Well, be that as it may, American companies operating overseas are going to be responsible both to the host country where they're operating, as well as a number of laws which have been passed in the United States that will apply to their activities even outside of the United States. Okay, what is the Foreign Corrupt Practices Act and what is the Sarbanes-Oxley Act? Okay, foreign corrupt practices, again, refers to activities we're doing in a foreign country. And so understanding that those countries have different ideas about what is common business practice, what is acceptable, there are some constraints that have been placed on American companies that deal in foreign arenas. And one of them is that you cannot pay a government official to give you business. Okay, that is barred by the Foreign Corrupt Practices Act. Now, the Sarbanes-Oxley Act, as we talked about, came out of a number of fraudulent things that happened in the early 2000s. And so this is meant to make financial transactions more transparent in companies that can be purchased by the general public. In other words, publicly traded companies. So there were some problems with auditors and management of companies cooking the book, so to speak. In other words, not accurately reporting what went on. So the Sarbanes-Oxley Act has some standards for auditing, independence, conflict of interest, and it also has some requirements that the corporate officers are going to be personally liable if they transmit bad financial information. Okay. What do we mean by stakeholders, and how do we determine whose interests are more important? Well, stakeholder is simply a term that means interested party, somebody that's affected by the decisions we make. So depending on what those decisions are, it can be a whole variety of different types of folks. Now, how do you weigh all those interests? You remember when we talked about decision making, we talked about sometimes there will be not a right-wrong decision, but a right-right. This is good for the employees. This is not so good for the suppliers or the owners. How do we balance those? And again, that's what we try and do the law tries to balance rights, and in our own decision making, we try and balance the relative goods. And many times there is not one right answer. Okay, so as I said, we're going to get into the substantive area now. So we're going to look in, the first area we're going to look at is torts. And that's probably not a word that's familiar to you, but that's a French word that means wrong. So we're going to be talking about wrongs. We'll talk about different types of torts. We'll talk about the elements, in other words, what's required to constitute a tort, the factors, so to speak. We'll talk about what the defenses are if it's alleged that you committed a tort. What defenses might you have? And we'll spend a fair amount of time on what we call intentional torts. So these are torts where intent is involved. It's something you meant to do. And then finally we'll wrap up and we'll talk a little bit about damages. In other words, what are the remedies? What do you get if you prove that a tort has been committed against you? Okay, well, this will take us back a little bit to when we first started talking about kind of the areas of the law. So we have some public areas, and the one we talked about was the criminal law, where the government is bringing the action. And we also talked a little bit about administrative law and regulation. And we'll talk much more about regulation down the road when we talk about government regulation, particularly of companies. And then there's a whole area of private law. And so most of our civil side is private law. And we'll spend quite a bit of time talking about torts and contracts, but it also includes property, family, etc. So this is the area of the law that deals between private entities, private individuals. Government may be involved in a private arena as well, but it's not enforcing a government right, so to speak. So we do make the distinction between public and private law, and we will be spending most of our time for the next couple of sessions on the private side with torts and contracts. Okay, so again, this is just a pictorial of the division, and on the criminal side, you could also consider that public, and so you might have government regulation over there. And again, on the civil side, in addition to contracts and torts, there would be property, family, and some other areas on this side as well. Okay. So, what exactly is a tort, and what's the difference with contracts? Again, these are two of the major areas of the law. So, a tort is liability that's imposed by law. So, this is where the law says you have liabilities because of something that's happened. And so I kind of abbreviate that. We can call that duties. This is your duty to other people. This is your duty to act in a certain way. Contracts, on the other hand, are agreements. So simple synonym is agreement. So these are voluntary associations that you have with people. So these are things that you've assumed on purpose. You've agreed with other people. You're having dealings with them. So we can abbreviate this as deals. So again, kind of a quick shorthand. Tort side is duties. Contract side is deals, making deals. Let's make a deal. Okay, so if we get right down to the definition of torts, even though that's a French word, I don't know where our little lawyer went that's supposed to tell us what a tort means, but tort means simply a civil wrong. Okay, why do we say a civil wrong? Because we have criminal wrongs as well, and we're making that distinction that we saw in the chart earlier. So this is a civil wrong. It's also shorthand to say it's an injury to a person or a thing, person or property. So if we are injured, or our house, car, whatever is injured, our other interests are injured, that would be a tort. Okay. Now, the same activity may be both a crime and a tort, and we talked about this early on. So remember the Simpson case where there were some people that were killed, and the criminal case was brought by the state. The government brought a case for the crime of murder. Okay, and so that was the criminal side. Now, the very same killings were the subject of a tort suit, a personal injury suit, and that was a suit for wrongful death. So the same killings constituted a crime, murder, and on the civil side, the people that were affected by the killings could bring a wrongful death action, an action for someone killing their friend's family, etc. So many times we will see, and particularly in this area we're talking about today of intentional torts, we will see that something can be a crime on one side where the government has an interest in prohibiting it, and then on the civil side it is a tort where the person that has actually been injured will be able to receive compensation for that. Now, got to say, sometimes there can be compensation for the victim on the criminal side. We talked a little bit about it. It's called restitution. Doesn't happen all the time. There actually is a criminal compensation fund that sometimes helps, but it doesn't happen all the time. You do have a right to bring a civil action to receive compensation for something that happened to you. A number of these torts also are handled administratively. So you recall a couple sessions ago we talked about administrative law, and we talked about departments and agencies that handle certain kinds of matters that could be or formerly were handled in the court system. So for example, workers' compensation, somebody's been injured, and at least in theory and formally, the person could have brought a lawsuit against who had injured them. We also have no-fault insurance, so if you're injured in an automobile collision, this would be something that you would bring a lawsuit. But because of the workers' compensation scheme and because of no-fault, some of these have been taken out of the civil justice system, the tort system, and they're handled now administratively. And these are decisions by the government that this is a better way of compensating people. So again, you look at the title, workers' compensation. That obviously is a government arena that is meant to compensate as well, and it was formerly part of our court system. Okay, so what are the purposes of torts? Well, as we've kind of evident from what we've mentioned so far, is it's mainly to compensate people for accidents and intentional wrongdoing. So the whole point of this is our involuntary problems that happen with other people that injure our person or our property. This is to compensate us, and by compensation we mean bring us back to as near as possible how we were before this happened. In other words, to reimburse us for costs and to give us some money value of things that have been done to us. Now, we talked about this briefly before, but if you lose a life or lose a body part or that sort of thing, you may not think money is the way to go, but that is, in fact, the way our scheme operates. So you can't replace those sorts of things, and money's kind of the best bet on how to return that value. Okay. Now, that's what we mean by making the victim whole. Again, obviously, if you've been damaged, have a permanent disability, you're not going to be whole again in that sense. But to the extent that we can do that through money damages, we will do that. Certain parts of our tort system also are meant to prevent this from happening again. And we will be talking about products liability, where one of the purposes of products liability is to get bad products out of the system and to charge people who have put bad products out with some money responsibility. Okay, and we'll talk about it toward the end, punitive damages, and these are to punish people who have intentionally done or recklessly done wrong, and so the punitive damages are meant to prevent that, to stop that, as well as deter or prevent other people from doing it because they see, okay, these damages have been awarded, we better be careful when we do this in the future. And then finally, what we're trying to do is we're trying to spread the risk around. We're trying to distribute the risk, and this is, again, we do that in some senses with our administrative proceedings we've already talked about. The tort system does some of that, and down the road we'll talk about certainly insurance does that as well. But this is all part of the idea of spreading the risk around so that it's not catastrophic for any particular person that gets injured, can't work, etc. So again, part of it is to spread the risk around. Okay, so we're going to divide our torts down into basically 3 categories, and we'll spend today talking about intentional torts. So obviously that has the element of intention, and you're probably aware intent is obviously part of crimes as well, and so there is quite a link, as we noted before, between intentional torts and the crimes. So there's going to be a lot of connection here. We may not see as much of it when we get into other areas. So the area of unintentional torts is what we call negligence. So by unintentional, obviously this is an accident. We didn't mean to do this. We were careless. We didn't follow what we should have done, or we did something we shouldn't have done. We didn't exercise appropriate care. So this is a fault concept. So by failing to do what we need to do, we're talking about fault. So we have intentional, then we have fault, and finally we have something we call strict liability. And strict liability is liability without fault. In other words, no matter how careful you are, if you fall within the purview of strict liability, you may be charged with liability. Now, why would we do that? Well, it's also known as absolute liability, and we attach this to certain kind of actions that we think are ultra hazardous or abnormally dangerous. So if you're dealing with flammable or poisonous things, if you're keeping a tiger as a pet, if you're doing something that's ultra hazardous, no matter how careful you are, the law may impose liability on you. And again, we'll talk about certain products that are considered unreasonably dangerous, defective, and so we will look at that down the road as well. But intentional, mean to do it; accidental, didn't mean to do it, but have some fault, careless; and strict liability, absolute liability, liability without fault regardless of what we've done. And today we'll be concentrating on the intentional. Okay, when we talk about intent, we mean we intended to do the action. It doesn't necessarily mean that we intended that particular harm. So if we throw a rock, we meant to throw the rock. If it harms somebody, we might not have intended that, but that's still an intentional act. Okay, if it was a joke or a compliment or we're trying to help somebody, again, if the act is intentional, even if the harm isn't intentional, that falls within this purview. And what kind of rights are we trying to protect? Well, divide those into 2. So we're talking about personal rights and business rights, or property rights. And so you can see a number of these are going to be dealing with rights of your person, right to be free of unwanted contact. So you've heard most of these terms: assault, battery, defamation, false imprisonment, intentional infliction of emotional distress, invasion of privacy. These are all torts. These are all wrongs done to your person. On the other hand, we have rights done to your business or property interest: fraud, trespass, conversion, interference with contract, or interference with business. So we do distinguish between torts to our person and torts to our property. You remember that we've defined torts as injuries to person or property, and this is kind of a convenient division in our intentional torts. Now, you may wonder, why are we looking at problems involving the person? What has that got to do with a business? Is a business going to do these things to a person? Many times, maybe not. But there's another reason that we are going to spend a little bit of time on these, even though they are against a person rather than against the business, and that's because a business may be liable for these things. So we'll cover this in detail later, but we're talking about something called vicarious liability. And this means liability for the actions of someone else. So this is probably familiar to you in the sense of if someone's driving a delivery truck and they harm someone, it's possible that their company will be responsible for those injuries. Okay, and it's called respondent superior, and that means that the employer, their superior, responds for the actions, for the torts of its employees. This also applies agency. And again, we'll be looking at this relationship further. but I just wanted to have you think about that's why we're covering some of these intentional torts that are against a person rather than specifically interference with a business, because they may come back to visit us as an employer. Okay, when we talk about the elements of a tort or elements of anything else, we're talking about the factors, we're talking about the criteria that we need to show in order to bring ourselves within that particular tort. So generally, we're talking about intention, which we already talked about. We're talking about a reasonable person standard. So we look to see how reasonable people will handle this, and that's kind of our standard. And we also, for the most part, need some kind of harm or injury. Now, the harm or injury may be assumed, and we'll talk about that in particular intentional torts. And there also would be other elements specific to that particular tort. But these are some general things we'll look at that will characterize intentional torts. Okay, now a reasonable person. Who is this reasonable person? And we did mention them earlier, and we will certainly mention them again. But a reasonable person is kind of a hypothetical or construct that the law puts out there for us to judge things against. So we're not talking about an average person, okay? And we're not talking about somebody that's perfect. We're talking about generally somebody that we would like to think is how we all act. In other words, careful, honest, aware of our environment, attentive. Okay, but it also is going to apply to the clumsy, the stupid, the forgetful. So we're going to apply the reasonable person standard even if the person we know that we're dealing with isn't that. So a reasonable person, when they're driving their car, does what? They're looking at the road, they're going the 3 car lengths behind, they're scanning before or aft, checking the rear view mirror, they're on top of things. So that's the reasonable person, that's what a reasonable driver looks like. Okay? But is that the average driver? Well, you've seen him as well as I have, you know, putting on making, talking on the cell phone, changing the MP3 player or whatever. Okay? So that's maybe the average person, but that's not the reasonable person. So we're looking for the reasonable person when we judge whether the behavior is appropriate and whether a tort has occurred. Okay, we'll talk about the elements, in other words, how we prove a tort, and then we'll talk about what the defenses are to a tort. And again, these will be specific, many of them will be specific to obviously that particular tort, but there's some that are kind of general. And by a defense, we mean a reason that's kind of an excuse, a legally sufficient excuse that means I should not be liable even though I did this act. So one that we'll talk about quite soon is consent. In other words, if I agreed to this activity, what's my objection? Okay. There may be instances when self-defense or defense of others or defense of property comes into play. So certainly there may be some actions that if you did them out of the blue are inappropriate, but if you're attacked and you're defending yourself or another person or property, then those are appropriate, and that would be a legally sufficient excuse or a defense. Okay, so we're going to look at assault, and many of you have heard of assault, and we typically hear about assault and battery, and most of you know this is also a crime. So if you whack somebody, you may be charged with a crime. But in addition, if you damage them, you may be subject to civil liability and intentional tort of assault. So what is assault? Well, it's intentional and unexcused. In other words, you don't have an excuse or a defense, and it creates a fear on the part of someone else, a reasonable fear, that there's going to be immediate harmful or offensive contact. So, again, we use the reasonable person standard, and you see a reasonable fear. So if you're a paranoid, scared of everything, that's going to be taken into account. So let's think about what some assaults may look like. So if somebody waves their fist in your face and says, I'm going to get you, okay, if you believe them, if it's reasonable to think that they're serious about this, then that would put you in fear. Immediate fear. okay, of harmful contact. So that would be an assault. How about if you're playing a game with somebody and, you trade punches, but you're not really trying to hit each other, and the person really doesn't think you're trying to hit them. You're just fooling around. Okay? Might not be. Okay? What if somebody sneaks up behind you and whacks you on the head? Well, there's certainly an offensive contact, and we'll talk about that with battery, but were you in fear of being hit? No, you didn't know. Fault's cracked. You didn't know it was coming. So there's no assault there. Okay. What about a bank robber shows a gun to a teller? Are they in fear? Probably so. Even if it's unloaded, doesn't matter. They're in fear of that. What if the robber says, I've got a gun, has their hand in a bulging pocket? Would that fear be reasonable? Could be. Okay, so again, we said assault and battery occur together, so let's see what the battery part is. And you probably figured this out if you didn't know it already. The battery is kind of the follow-through. So the battery is the hit. Okay. So it's harmful or offensive conduct, and it can include someone's clothing, touching them. Often occurs with battery, with assault, but it doesn't have to. So you can have assault and battery separately. Now, if you mistake somebody, you think they're a friend, you go up and hug them, and they're offended. Can a hug be a battery? Well, it certainly could. It's offensive. It doesn't have to be injurious. It doesn't have to be harmful in that sense. Obvious example, somebody grabs your purse. They haven't touched you, but they've touched your purse. That could be battery also. What if you kiss your girlfriend or boyfriend while they're asleep? They don't know it. You tell them later. Well, that's unwanted touch. So that could be a battery as well. You go to your doctor. Doctor gives you a flu shot, didn't ask you. May be very helpful to you. Maybe you needed it, but it's unwanted. They didn't have permission. That could be a battery. Okay. So a lot of times we're looking at, again, the kinds of defenses we have, and what would be defenses would be consent. Okay, so if somebody punches you, it's an assault, but what if you're in a boxing match? You've agreed for enough money, take your shots. Okay, so consent will certainly be a defense. What if you get bumped into in line? You're in a busy line, people are bumping into you all the time. Is this battery? Well, just as a practical matter, in a crowded society, there's a certain amount of bumping into each other. Maybe a question of whether it's intentional or not, people crowded, but the law is going to take that into account as well. And of course, the law will take into account if you have a relationship or prior dealings with somebody and they change their mind, they don't want to be kissed now. Well, if you don't know that, then it's not an intentional act. Okay. Once you do know that, it is. And we may revisit this again when we talk about harassment, that sort of thing. Okay, another tort is conversion. And conversion is really simply the civil side of theft. So conversion is taking someone's property or depriving them of the use and putting it to your own use. So conversion you can think of as the civil side that you have remedies for, and on the criminal side, this would be theft. Okay, defamation. Okay, you've probably heard some of the types of defamation. You may not be familiar with defaming someone, but defamation is making a false statement about someone, a statement of fact, and this statement damages them. It harms their good reputation, their business, etc. And a key element here is that it has to be transmitted, it has to be communicated to someone other than the person you're talking about. So if you are simply in front of someone and say something rude, that's not going to be defamation. And we have two different types. We have oral, which is called slander, and if it's in written form or some other fixed form, we call that libel. So you may have heard the terms libel and slander. And again, although we hear them together, they could be separately involved as well, and frequently are separate. Okay, so we have an untrue fact, damages someone, and we communicate it to someone else. Okay, now defamation per se means that we don't have to show damages. Okay, so there are four things that if we say them about someone, they don't have to actually show that their business or reputation or whatever was damaged, because we're going to assume that these are horrible things. And so we're going to assume that if you say someone has a loathsome communicable disease, has committed professional impropriety, dishonest in their business, has committed a serious crime, or if an unmarried woman is unchaste, okay, sexual indiscretions. So this is one of the few areas, you can see this common law still, where we make a gender distinction. Okay, so it's a unmarried woman is unchaste. And these are considered defamation per se. Again, common law from, the mists of time. And if you say any of these things, then we don't have to show damages. Okay, the rules differ if we're talking about a public figure. Okay, and this is actually quite different from British law, but a public figure has less protection than the average person. So that's why you can see in the supermarket tabloids, you can say lots of different things about people. So who is a public figure? Well, it's a government official or someone that's out there in public, and more frequently it's a celebrity. So it's a movie star, that sort of thing. And if you are considered to be a public figure, then you have a harder time proving that somebody has defamed you. Okay. To prevail, you need to show what's called actual malice. And that means that you need to show that the statement was made with knowledge that it was false or reckless disregard for whether it was true or not. Okay, so you need to prove more. It's a higher standard of proof if you're a public figure and you're trying to claim that you were defamed. So if we think about it, how do we distinguish between libel and slander? Well, it's whether or not it's in a fixed form. So if it's on the radio, what do we got? Okay, that's oral. Okay, if it's rumor spread around by people, word of mouth, that's going to be oral. Okay, what if it's on TV? Okay, well, it sounds oral, but guess what? We got TV taped, right? So it's probably going to be libel in that case because it's in a fixed form. Same thing with the things we put on the internet, movies, that sort of thing. Okay, so that's how we distinguish between libel and slander. Libel, we're going to assume damages, but slander, unless it's per se, we're going to need to prove our injuries. Okay, we have intentional infliction of emotional distress. And I have to say, this is generally, although it's a tort by itself, it generally attaches to other actions as a practical matter. But what do we mean by intentional infliction of emotional distress? Okay. Well, we mean that somebody is creating distress on purpose. It's harmful to the plaintiff. It's the type of thing that you're saying that would be offensive to a reasonable person. Again, we're not talking about an overly sensitive person. And again, courts generally are going to want to see some kind of physical symptomology, some effect, some illness, something happening. Again, it's not a firm requirement, but generally they want to see this as illustrative that this has actually happened. So what kind of things would be so outrageous? Well, it might be making fun of somebody whose loved one has died. If a child drowns and somebody calls up and makes glug glug noises, sings the Little Mermaid song or something of that type to intentionally distress the person that they're talking to. And we would consider that to be outrageous, and we would consider probably that the reasonable person that had this happen to them would be offended and might be affected in various ways. How about if we're leaving rubber spiders or cockroaches or snakes in somebody's desk drawer? Well, a reasonable person might not be affected that way. So unless we knew that they had arachnophobia or were terrified, of spiders or whatever and might have a heart attack, then that might not be intentional infliction. So we weren't intending to have that kind of distress happen. Okay, false imprisonment. Okay, so we intentionally confine or restrain somebody. We do not have justification. And this can be either physical barriers, physically holding them, or threats of physical force or violence. And there are some exceptions if a merchant has reasonable cause, for example, to think that you are shoplifting. So let's look at some possible examples. What if we lock somebody in a room and it's just as a joke? Ha. Well, again, we intended them to put in there. Even if we didn't intend the harm, we have probably committed false imprisonment. Okay, again, if you're accused of shoplifting, you're told to stay in a room until the police come. Well, have you been restrained? Okay, so first thing we'd look is the probable cause if they actually did restrain you. But in this case, have we been restrained? Well, if we've been told something will happen to us if we leave, physical violence or something, maybe. But if they just say stay here and we stay there, probably don't have the restraint that's required. Okay, for what if we trespass into a farmer's field, comes out with a shotgun and says, don't move or I'll shoot you? You bet, we're restrained. Threat of violence will keep us there, so we've been falsely imprisoned. Okay, trespass to land simply means that you've entered without permission, can be above, below, on the land. You can commit a trespass even if it's not your person that goes on, if you cause something else to go on to the land. And again, you don't have to show actual harm to the land. It's the mere violation of the land that constitutes the offense. So what are some possibilities with trespass? Well, you get lost and you go onto somebody's property. Didn't mean to do it. Okay? You probably committed trespass. Okay? What if you're burning leaves and your smoke blows into the other person's yard? Well, you have trespassed. It's not you, but it's your smoke. So you have caused something to trespass. What if you go on to another property to stop something bad happening? So a brush fire that you didn't start is there, or flooding or something, and you go on to the other property and you're trying to help. Again, the intent on that, the intent is the intent to do the action, and even though it doesn't cause any harm and it might actually provide some help, technically you have trespassed. Interference with contract, and there's something similar called interference with business relationships. So here we have a contract that's in effect. The defendant, the person, the wrongdoer or the tortfeasor, knows that there's a contract, and the wrongdoer intentionally causes a party to the contract to breach it or makes the performance impossible. And this harms the plaintiff. This harms the other person in the contract. Okay. This is a tort. So if you steal somebody away improperly, then you have committed this tort. Now, how about just regular competitive stuff? We offer better deals, et cetera, et cetera. Okay, it doesn't stop competition. And again, we'll talk about competition more when we talk about antitrust and some other areas, but this doesn't really prohibit competition. It prohibits improper inducement of somebody to get out of a contract. Okay, invasion of privacy. Okay. This is changing dramatically, and in one of our sessions we'll be talking about how the internet impacts things, and certainly it's a lot easier to invade people's privacy now when everybody has a camera on their cell phone and we can post things, etc. But typically when we think of invasion of privacy, we think of a couple things. One would be appropriation, and that's simply taking somebody's image, somebody's proper picture of them and using that to make money. So this would obviously happen more often with a celebrity. So if you use somebody's image, that's an invasion of privacy as well. The other area of invasion of privacy is intruding into someone's affairs and publishing something that they have a reasonable expectation would be private. So you're publicly disclosing something that we reasonably expect would be private, and it's objectionable. So you frequently see pictures taken of people, and if somebody has been a peeping Tom, in other words, if they've peeked through your window or gone over a fence or gone to a place where you have an expectation of being private and they've taken pictures of you, that would probably constitute this. Now, if they take a picture of you walking down the street, maybe not. If they use it for gain, they may be subject to appropriation, but if they simply take a picture of you and post it, have they invaded your privacy? Well, the question would be, did you have a reasonable expectation of privacy when you're on the street? Okay. So, again, everybody with his cell phone and a video camera has changed the game here, obviously, a bit. Okay, misrepresentation. Okay, this is also referred to as fraudulent misrepresentation. And what's important here is it's a misstatement or admission of a material fact. And we'll look at material fact in a minute. It's made with the intent to deceive somebody, and it does, in fact, deceive them. So you intend for them to take action based on this fraudulent misstatement that you're giving them, and they do, in fact, rely on that. So they have reliance on what you've told them factually, and this constitutes fraudulent misrepresentation. Okay, generally, what is a material fact? This is a fact that a reasonable person would consider important in deciding what to do or buy. So we're not talking about an opinion here, and we're not talking about seller's talk or puffery. I think the term puffery is a marketing term, but it's kind of like a puff of hot air. Somebody is telling you something that isn't true. So when we talk about material fact, we're talking about a fact that would make a difference to you. Okay, so let me give you a little example here. Okay, so we have this nice young lady, and she is telling us that if I use this fine product here, that this will improve my social life dramatically, and folks of the other gender, or whatever gender I like, will gather around me and change my life. Okay. Now, reasonably, am I going to believe this? Is that a fact? Well, that's probably more of an opinion. So, setting aside the fact of problems I'd have at home if this was an effective product, what if it isn't an effective product? It doesn't have people coming around once I use this. Has this young lady fraudulently misrepresented? No, because this is an opinion. This is seller's talk. This would be the same thing as saying world-famous hamburgers at a place that nobody in the world has heard of. We don't rely on these. A reasonable person wouldn't think that that's true. Okay, so that's what a material fact is something that we would rely on. So what might that look like? Okay, 100% Kona coffee, koa wood, made in Hawaii, microwave safe. So what is it about these? These are facts. So we're saying I would pay extra for Kona coffee. Okay, so if it's not Kona coffee, I wouldn't pay the premium. I want koa wood. If it's monkey pod wood, I wouldn't have bought it. If I buy something microwave safe, put it in the microwave, it melts, I wouldn't have bought it. So these are facts that would influence our decision. What would be a non-material fact? Well, okay, we've got Cheerios here. It says 2 pounds, 5 ounces. What if I actually took out my scales, not my law scales, but my atomic scale, measured it, and it's actually 2 pounds, 4.999 ounces. I mean, really, do I care? There may be some labeling issues, there may be other issues, but that's not material. That's not going to cause me to buy it or not buy it. Now, what if it isn't whole grain? Well, I may be interested in whole grain because something my doctor told me. If it's not whole grain, I wouldn't have bought it. That's how we know it's a material fact. Is it a fact that would influence our decision that we rely on? Okay, so damages. Assuming that we have proved one of these intentional torts, what do we get? Again, the solution to an injury to our person and property, for the most part, is going to be money damages. So we're going to be looked to be made whole, as we talked about, or to be compensated for the losses or injuries that we've suffered as a result of this wrongful action by someone else. So compensatory damages are going to be the damages that help us recover what we have lost. And again, money is the medium we're going to use. It may not seem appropriate for death, for certain types of injuries, for disability, etc., but there it is. We are talking money. Just incidentally, if you've never looked at the workers' compensation law, you may find it interesting that the workers' compensation law actually puts a value on your body parts. So if you lose an eye or a finger, there's actually a designation of how many times a certain weekly wage you would get. So that's a little distressing. I guarantee you would not sell your kidney or any of your other body parts for the amounts listed there. But again, by compensatory damages, we are attempting to make the person whole. We talked a little bit about punitive damages. Punitive damages are the damages that are meant to punish the wrongdoer because they've done something very reckless, outrageous, and so we want them to be punished for doing that, and we want to deter, to keep other people from doing that because of the fear of having this kind of damages. So if we receive compensatory damages, that means that we have been made whole, and the punitive damages are on top of that. So the compensatory damages would be paid, and they would be based on what's necessary to make the injured person back to normal as much as we can. But the punitive damages, we won't look at the injured person as much as we'll look at the defendant, the wrongdoer or the tortfeasor, and we'll see what amount of money would punish them. So in that instance, we're looking at the defendant to see how much would we need to award to punish them. So for example, if Ford Motor Company produces, or another manufacturer produces, a car or truck that is dangerous and it damages people, and they knew it was dangerous and they did it anyway to make profits or because changing would cost too much money, then we may be distressed that they've made that judgment about okay to kill a few people, and we may do punitive damages. And of course, with a major company, it would have to be a substantial amount. Whereas if a mom and pop business had done something we thought was outrageous, a few $1,000s may get their attention, wouldn't get Ford's. So again, the punitive damages would be based on the defendant, on their net worth, etc. And we will talk a little bit more about that when we talk about strict liability and products liability, the use of punitive damages. It's a controversial area. Okay, and finally we have nominal damages in name only. And these damages are simply damages to show that you won. So we have a case that you will look at online where the damages were nominal damages. It was in a defamation case. In other words, something had been said about somebody that purportedly damaged their reputation, and they were awarded $1. So that's nominal damages of $1. Now, you can bet that lawsuit cost them a heck of a lot more than $1. So what was the point? Well, the $1 was to show I've been vindicated, I was wronged, I win, and that's what it is to show. So it's nominal. Okay. In compensatory damages, two kinds. General damages are the harder ones to figure out, and these are kind of estimates. And special damages are the ones that are kind of logical for you. So special damages would be the things that are capable, easily capable of calculation. So if you're in an automobile accident, that would be damage to your car, if your clothes were torn, your medical bills, you lost wages. These are all amounts that we know exactly or pretty close to what they are. And so those would be what we call our special damages. The general damages would be the kind of more esoteric damages, just as real but not easy to calculate. So that would be, for example, our pain and suffering, if we've been disfigured, that sort of thing. So those damages are much harder, and this is where the judge or the jury, and as we saw in the video, typically an injury case is a jury. That's where the jury would try and figure out what would be appropriate compensation for someone now who is in pain every day. And this tends to be per diem. In other words, as was in the video, if you only award my client X number of dollars per day, they're going to live 25 years, that would be this amount of money. So much harder to calculate, but it's certainly an important part of what has been lost. Okay. Now, the final area we want to talk very briefly about is, although almost all the time we have damages money results for our lawsuit, for our tort suit, on occasion we will have an injunction. An injunctive relief is equitable relief, and this is the court telling somebody, do something or don't do something. And you may be familiar with temporary restraining order, frequently saying don't come close to someone, stay a certain distance away. So the injunctive relief is the court telling someone do something or don't do something. And the idea is to prevent some future harm that we think is immediate and irreparable that's going to happen. So we think that we need a court order to prevent that from happening. And just an easy example concerning one of the intentional torts we've already looked at is if it appears that you're going to publish something about someone that is defamatory and it would injure them, then you can prohibit that. You can say you can't publish that. And again, next few sessions we'll talk about how easy it is to get information out there. This area of the law changes dramatically because of the internet and the ability to disseminate, etc. Okay? So we have taken a look at the intentional tort area. I would like you to look at all the additional materials. Now that we're getting into the substantive law, please look online at the materials there that will help explain as we get into torts and contracts, etc. So take a look at the intentional torts and the negligence that we will be moving into shortly. And as I said, next big area is going to be unintentional torts. So it's going to be what we call negligence. That's typical accident, injury kind of law, didn't mean to do it, careless, etc. So please take a look at those materials. So this is Ben Carroll saying aloha. I will see you next time.